Fani Willis admits she's got a personal relationship with Nathan Wade. We've all known this, but she put it in writing now, and she says that's not a big deal at all. Who cares if we're in love? We didn't taint this case with any of our, indictments of each other on cruise ships. We used our personal money for this. We didn't have anything to do with taxpayer money. There's no improprieties here, and leave us alone, essentially. It's the true love defense. And we were kind of hinting at this a couple weeks ago when this all started to break. It's like, Fani's gonna say, how dare you? I was lonely. I was under pressure, and I needed the comfort of a Nathan Wade hot dog, which we heard from a woman in Georgia that exists there. But Fani issued the response. We're gonna hear Donald Trump's reaction as well and remind ourselves about a hearing that's coming up and then talk about this, because do we really want Fani going anywhere? I mean, she's kind of amazing for this whole charade. She's kind of like a lightning rod, a shiny object that we're all going to be able to pay a lot of attention to. It symbolizes and crystallizes how corrupt this whole thing is. So we kind of maybe want to keep her around. Let's see what she says. This is the response from Fani Willis into the court. You see, Fulton County, where Big Fani reigns. The case is the RICO case, 19 co-defendants. Several of these people have already taken diversion deals. They are not going to be convicted of anything. Sidney Powell is one of them. But here is what Fani wrote back to the court. She says, comes now Fani in my office in Fulton County, and we oppose the meritless motion to dismiss that was filed by Michael Roman, shout out to Ashley Merchant and that team there, and joined by Donald Trump and Robert Cheeley. Trump joined that motion and said, there's a lot of problems here, because after this allegation was even made, Michael Roman submitted his motion via Ashley Merchant, the attorney in Georgia. What happened is Fani came out and responded to that. She gave her a little talk at the church and said, this is racism. And we said, how is it racism? Because we're not talking about race, you are. We're talking about whether you slept with somebody or not. In this case, the allegation is you slept with Nathan Wade. If you would have slept with Nathan Wade and the white guy, who happens to be a RICO expert, which is pretty racist that you didn't sleep with him too, well, then we wouldn't have anything to argue about. We'd say, well, okay, well, I guess you slept with everybody. But she didn't. She only slept with one person as far as we know. So then she said it was all racism, and she's speaking and communicating to all of prospective jurors throughout Fulton County. So Trump said that is not appropriate. And let's just zoom out quickly. The standard here in our justice system is not actual improprieties. Like, you don't have to be caught with Nathan's hot dog in, your prosecutor's office or something. But even the appearance of impropriety is the problem. We want our justice system to be neutral. We want our prosecutors to be above reproach. So she's right in the middle of it. But here's what she says. Now, while the allegations raised in the various motions are salacious and they've garnered media attention that they were designed to obtain, none of those allegations provide this court with any basis upon which to order the relief they seek, which is either to disqualify Fani, there are two issues here, or to dismiss the case. And so let's pay special attention to both of those features, because a dismissal would resolve the whole thing, right? A dismissal means you don't have to disqualify anybody. The judge would say that the facts of this case are so tainted by this corruption that there is no way that this can be fair and impartial. All the evidence is bad. It's, whatever he comes up with as justification. Dismisses the case. Boom. That's the Super Bowl. Case closed. Don't have to talk about disqualification anymore. The likelihood of that happening, I think, is quite low, because what they're going to say, it's not material to the actual facts of the case. The evidence is separate and apart from their hot dog relationship, where they're indicting each other on cruise ships and going to Napa Valley. But that is something that I think the judge will say, I can cordon that off. I can put a force field around that and protect the evidence. And then, honestly, it's your job to cross-examine the evidence and impeach that evidence to say that the evidence is not sufficient in court. And if you want to bring in maybe some of this relationship stuff to show that, then we'll have to battle about that via, motions in limine, admissions, relevance, objections on all the stuff. In other words, the judge will say, I'll deal with it at trial. But here's what Fani is saying. So now if the judge does keep the case, then the next step would be whether we disqualify her. Now, here is what they say. Fani tells us, now, unequivocally, the evidence and the facts demonstrate, and we're going to really have issue with that unequivocal word, but here she says, DA Fani has no financial conflict of interest that constitutes a legal basis for disqualification. So two parts that, right? With a modifier. Does she have a financial conflict? Because on this channel, we've chronicled this clearly. Nathan Wade got about $700K, and the others got a lot less than that. They got, I think, under $100K a piece, and they were actually more qualified, in my opinion, than he was. So we have 7-to-1 ratio there. Why is that? Now, that's a conflict because she, according to billing records from Nathan Wade's divorce proceedings, some of that money, presumably, I don't know if he was working or getting funds elsewhere, but some of that money, presumably, was going back to the enjoyment of Fani on cruises. We've got plane tickets that were being bought, Napa Valley, all the things. So there is a conflict, but maybe she says it's outside of the scope. It's too far removed. Who cares about this? So it's not a basis for disqualification of her office. And she might be right about this. We'll see. Now, Now, DA Attorney Willis has no personal conflict of interest that justifies her disqualification personally or that of Fulton County and the district attorney's office. Now, obviously, if there's a financial conflict, you can say, well, if you're sleeping with the dude who you're paying and you're going on cruises, maybe that is a personal conflict. But again, these are just issues, remember, between, Nathan and maybe the taxpayers of Georgia. Maybe the voters can take a look at this. Maybe, come up with some legal justifications for why this doesn't matter. I'm talking he, the judge, why this doesn't matter to the case. But think about this also related to Trump, because this leads to the prosecution of Trump and Mike Roman and the other co-defendants in order to rack up the bill, right? It's prosecution for pay. So she wouldn't be able to go on cruises and go to Napa Valley and sip on wine with Nathan if he wasn't getting paid all this extra money. Now, the attacks on Special Prosecutor Wade's qualifications, we have the we're truly in love defense, the true love defense. And then we also have Nathan Wade is highly qualified defense. These are malicious attacks on him. And so even if he's not qualified, this is no basis to dismiss the indictment or to disqualify the special prosecutor. I think that's a good point, which is honestly kind of why it's like we might want to keep Nathan Wade around. We might want to keep Fani Willis around because they're incompetent. Why would we want them going anywhere? Yeah, he doesn't even take notes as far as we know. And so far, their track record on this case has been terrible. They've got 4 diversion agreements, which means 0 conviction. And I know a lot of lefties really hate that, but it's true. Go read the documents. Don't take my word for it. It's there in black and white. It's still posted on my X account if you want to go take a look at it. 0 convictions they've gotten from this. No Sidney Powell, no Jenna Ellis. Weird. How come? They were supposed to be some of the masterminds behind this whole operation, weren't they? You got nothing on them. And then we saw actually Fani Willis in action. I almost forgot. She came out and she argued at that Harrison Floyd proceeding and she did terribly. She lost that. And we were sitting here going, is she nuts? What is she going through all this motion for that, Harrison Floyd she wanted him back in custody, and Jenna Ellis supported that, by the way. And what ended up happening is the judge said he didn't have any notice that he was not allowed to do this. Obviously, that was going to be the outcome. And she was like, hi, Your Honor, lost everything because she is not good at it. Neither is Nathan Wade. And when you zoom out on this even further, think about this. Look, if you have a group project, rewind yourself back to high school or college or something, okay? If you're going to go over to your love affairs, dorm room or whatever, to do your homework together, how does that ever work out for you? Okay, it doesn't, right? We're all aware of this. Yeah. We'll come over. I'm gonna come over there and we're just gonna study together, right? We'll study for finals together. Yeah, you and your love interest. Does that ever work? No, it doesn't. Okay, or maybe it does, but it's like, what's your output capacity? Are you at 100% production there? Are you really focused on that 100%? No. Maybe you get like 60% productivity versus, let's say, 2 prosecutors who are dedicated to not indicting each other on cruise ships. If they're actually focused on the case, right? The 2 top dogs here, Fani and Nathan Wade, if they're actually like grinding because they're not jousting each other, whatever they do in their bedrooms, their prerogative, but that would be, you'd actually turn out some work product, I guess is what I'm saying. And they weren't doing that. So the point is it's showing up in court. So District Attorney Willis she's made no public statements that warrant disqualification or other judicial inquiry. Doesn't even want to talk about it. And the public statements she did talk about it. She actually did make public statements about it. We listened to her in church. She made 30 minutes of public statements to her constituents complaining that she's lonely and she's under attack by racists for sleeping with somebody and then paying him almost $1 million. So she also says, now criticism of this process that we utilize to appoint and compensate demonstrates a basic misunderstanding of the law. We're all just idiots, but it provides no basis for dismissing the indictment. So she's going to try to cordon herself off, and I think she's probably going to be successful. I think the judge is maybe likely to keep her. Let's see. Let's finish. Says, now the motions have no merit, and after consideration of the attached exhibits, including the sworn affidavit of Nathan Wade that we're going to read, this should be summarily denied without an evidentiary hearing, and that's what they really want to avoid. They've done a very good job of putting the lid on the divorce. Remember, Nathan Wade was going to have a hearing this week to talk about the divorce. Fani had a subpoena, and all that got quashed. They don't want to talk about this. They're in cover-up mode. So here, the motions identify no conflict of interests. She says, Georgia courts have long recognized there are 2 accepted grounds for disqualifying a prosecuting attorney. So Georgia standards, like forensic misconduct, there's no forensic misconduct here. They say defendants do not point to any action that has been outside the character of an officer of the law, that's specifically charged to oversee either the special grand jury's purpose or the prosecution of these defendants. So think of it, it's like, forensic misconduct or something. If a crime lab technician swapped labels on DUI vials and the district attorney covered that up or something, okay, that's like an egregious, thing of misconduct. But jousting your, or hanging out with your special prosecutor or being jousted by him is, not something that rises to that level. So she's reading this very narrowly. A forensic misconduct is only one of the things, and I didn't do that. Now, the motions attempt to cobble together entirely unremarkable circumstances of Nathan Wade's, his appointment, with completely irrelevant allegations about his family life. Now, this effort must fail. Say, for a prosecutor to be disqualified, it requires, quote, a personal interest, and a district attorney is not disqualified by personal interest in a case where he was not acting in his personal or individual character, but in his character as an officer of the law. Now, a conflict arises when the prosecutor has a personal interest or a stake in the defendant's conviction. Now, see, that's where I would say she does, absolutely. The more hours that Nathan Wade bills, the more money he has to spend on her to go into cruise ships and other things. Now, a charge that no defendant offers any support of beyond their fantastical theories, what I just came up with one, and rank speculation. So they say you need more than that. Well, we have actual like travel logs, Fani. Let's see. A conflict of interest requires more than a theoretical or speculative conflict, and an actual conflict of interest must be involved. He got paid 700 grand. You guys went to Napa Valley. Now, under the clear definition supplied by the law, they say we don't meet the standards. We don't have a personal or financial interest in the conviction. Conflicts that fall into these categories, you know, we got a lot of case law here, so we're fast forwarding through a lot of this. But here, they say all of these circumstances can create a personal interest, but none of those apply here. So they give us a couple narrow examples. Here, like here's a conflict where a DA represented a husband in a divorce proceeding at the same time that he was participating in the prosecution of the wife for shooting the husband. Like, that's a pretty serious conflict. He's representing the husband and he's also prosecuting the wife. I'm going to put her in jail and you're going to get a smoking deal because I'm going to put her in jail. Like, you're going to get the house and everything. Why? She's going to jail because I'm prosecuting her. Like, that's a conflict clearly. So she's saying it has to be like monstrous, not the fact that they're just indicting each other. Now here, similarly, like if a prosecutor is a fact witness that provides incriminating evidence about the defendant, but none of that applies here. So all these examples are outside the scope, she says. Now, finding of a financial conflict on the prosecutor's part is exceedingly rare, and that's to her benefit, but has been found to arise when a special prosecutor is compensated by a contingency fee. Well, we know contingency fees for convictions, like those are hard no's. A contingency fee is something like in a personal injury case, right? Like you don't pay unless we win. So, you know, your personal injury attorney, you get in an accident, you lose your leg, you get $1 million. The attorney says, we're going to take a contingent fee. We're going to take a third of the settlement. They get 300 grand. You take the rest. You can't do that in criminal law. Like, we'll only pay you if you convict this dude, because that causes some pretty perverse incentives. We're not paying per convictions. We're paying for justice. This is why prosecutors are not supposed to be like overly partisan prosecutorial hacks. They're supposed to be people who just do justice under the law, right? We don't want them to be weaponized and incentivized financially to go after people. So this is obvious. Like the fact that she's like bringing this up is like, you know, first year criminal law. Courts have held that incentivizing a prosecutor to secure a criminal conviction creates a conflict. Like, okay, like we've got that. But again, none of the circumstances that could support this here exist. So it's not a contingency fee, right? She's just paying him hourly for the work. Now he happens to be billing the hours like up massively. Like those numbers were accurate, reported by the Atlanta Journal. They said that Nathan had billed 700 grand, the other two less than 100 grand. And guess who's approving those billing reports and approving those contracts? Fani is, like by her signatures. But again, none of those support this here. Now they say that Fani, her state and county compensation is set by law and is not in the least bit reliant or dependent on the outcome. So Fani, right, she says, my pay doesn't change. Whether Trump gets convicted or not, I get a salary. I'm just a government employee. Now, defendants attempt, now the argument, of course, is that, okay, we know that, like your money's not going up. That's the problem for you guys. So that's why you're funneling your money over to Nathan Wade so that you can funnel the taxpayer funds to him and then he can take you on the cruises. Now, she says that the defendants attempt to conflate media attention with personal financial gain is complete conjecture. One could speculate with the same confidence that a decision not to seek charges or to seek different charges arising from the same set would result in comparable media attention. Yeah, but if you did not seek charges, then Nathan Wade wouldn't be able to bill. He's billing hourly, Fani. So the personal financial gain is connected. Like, this motion is so dumb. The personal financial gain is connected specifically to the fact that you continue on with this. He gets to bill every day he shows up in court and ignores that DA Willis has attracted both positive and negative publicity to this case, which includes ongoing security threats. Yes, we know. Racial slurs. Yes, we know. Sexual invective. Like what, Fani? And attacks. Well, She's a prosecutor, for crying out loud. Give me a break. The biggest one in Fulton County. Get so tired of this stuff. Like, how are you going to incarcerate gang members and cartel, leaders if you get shook when someone calls you Big Fani? Relax. And most importantly, this fuzzy concept of personal or financial interest via media attention is simply not a definition that's ever been recognized by Georgia law, right? Of course, because it's probably never happened before. That the special counsel was indicting the DA herself. Incredible. Now, fair consideration of any benefit to the prosecutor. If Fani got any money, like if we're going to disqualify her, it's about her. To the prosecutor, it must include these obvious and undeniable costs. And any spurious allegations of publicity seeking aside, which I think this is in response to Trump saying you sought publicity to expound on this issue, basically to defend yourself in the court of public opinion. And that was jeopardizing the jury pool. And you're not supposed to do that. You are already a prosecutor. You already have throngs of power. You don't also get the power to go out and use your office to castigate the opponents. They're already the defendant. So it must be made clear that DA Willis did not go looking for this case, which is a weird thing to even put in this. Hey, don't look at me. I didn't want this crap. These defendants centered their racketeering conspiracy in Georgia. So it's their problem, right? Their crimes gave it to her. It's in her jurisdiction. And so the motions are based on guesswork and public relations strategy and not legal argument. A conflicted prosecutor presents a risk that he or she will disregard public interest for personal benefit, which is exactly what we're talking about here. Yeah, racking up the bill, pay for prosecution. No circumstances alleged by any of these defendants even approach that threshold, let alone cross it. And the accusations brought to this court by these defendants on the flimsiest of factual support may cause a reasonable person to wonder the defendant's motivation is more tactical than legal. I think we're missing a word there, no? May cause a reasonable person to wonder the defendant's motivation is more tactical. I think we're missing whether, no? To wonder whether the defendant's motivation is more tactical than legal. Now, one may question whether, there that word is, the intent is to disqualify the prosecutor who has taken on all of the abuse to pursue justice in this case at great personal cost, only to be substituted with someone less committed to do so. This is horrible. I can't even take it. Wow. Okay, so who has taken on all the abuse to pursue justice in this case at a great personal cost? So she's the victim now, and that's why this case shouldn't be dismissed and pursued justice? Our tenses are wrong. Who wrote this? Did Nathan Wade write this? So anyways, like the grammar's off. Now, any personal relationship among members does not amount to a disqualifying conflict of interest. Now, much of Roman's motions relies on supposition and innuendo. It actually doesn't. Like, they have billing records regarding the private relationship between Fani and Wade. It is distasteful that such allegations require a response. I'm sure you don't want to talk about it. Yeah, but it's true. It exists. But for candor's sake, and to provide the court with sufficient facts to resolve this matter efficiently and consistently with the manner in which other potential conflicts of interest have been handled, the attached affidavit of Nathan Wade makes clear that Roman's insinuation that his counsel was aware of material in the sealed divorce filings, his counsel was aware in the sealed filings that would in any way support disqualification or dismissal in this matter was a blatant misrepresentation designed to seek publicity instead of a meritorious legal remedy. Now, the affidavit, they say, also clarifies that Fani and Wade have been professional associates and friends since 2019, and there was no personal relationship between them in November 2021 at the time that Wade got appointed. But I don't know about that, because as soon as he executed the contract, the next day he filed for divorce. Why is that? That's a pretty big coincidence. My goodness. And defendants offer no support for their insistence that the exercise of any prosecutorial discretion, this is the point, right? They're going to say relationships in this hula hoop, in this bucket, and all the prosecutions in this bucket. And the judge is probably going to find a way to keep it this way, which I think is actually a good thing. We'll talk about it. Now, in this case, nothing was impacted by any personal relationship. So without those additional factors, the existence of a relationship between members of a prosecution team in and of itself is simply not a status that entitles a criminal defendant to any remedy. That's the point, is we're not saying it's in and of itself. Like, there's a lot more to this, including $1 million. So Georgia courts have held as much for decades, both in civil and criminal context. So now their goalposts just moved. So now they're going to argue all about prosecutors are allowed to have relationships. we say, yeah, that's not, sure, I'm sure that's true, but that's not what we're talking about here. So now they're going to give us this whole paragraph about, prosecutor married an attorney who represented a criminal defendant in an unrelated case and all this crap. It's like, okay, no one cares. It does not follow that professional people will allow intimacy to interfere with their professional obligations, right? And we have found no authority that married lawyers who are involved in active litigation on opposing sides must be disqualified, right? Like, it's lawyers are people too. We are, believe it or not, some of us. Not a lot of prosecutors though. Defendants' motions do not cite to any of this controlling case law or any other authority. And they say, it's worth noting that there are at least 2 personal relationships among the collection of defense attorneys. Okay. Are they also using taxpayer money to fly around and go to cruises? And they're also getting paid by the hour from the coffers of Georgia? This is so bad. Well, they're doing it too. It's worth noting that there are at least 2 relationships among the collection of attorneys that are representing the defendants. Oh, wow. Oh my gosh. They're throwing this is like high school. Now, under the standard urged by Roman's motion would almost certainly require disqualification. Amanda Clark, who's representing Smith, and Scott Grubman, representing Chesebro, they're having a personal relationship too. Okay, well, that's great. They're allowed to do that. Are they in the same office, first of all? And does their HR, company, they have a position on that? And is there a hierarchy of positions there, right? So is there a power dynamic there between the two? Probably not. And is there $1 million of Georgia taxpayer monies that are being funded to them to defend their clients? Answer, no. But they did it too. And so we did it too. Again, she's going back, she's forgetting everything else. She's like, forget everything else. Forget all of the evidence. We're allowed, prosecutors are allowed to be in a relationship. And we say, yeah, that's absolutely true. Of course that is. Lawyers can be in relationships too. It's the cases that you're on and how you're prosecuting those cases and whether you're laundering $1 million. So since Chesebro has already pled guilty and agreed to testify for the state about nothing in the upcoming trial against Smith and other remaining defendants, one who is ill-informed about this, one might argue that their relationship could also rise to a conflict of interest there. That's inculpating Clark Palmer's clients. Okay, that's a stretch. Now that, of course, would be an incorrect conclusion to draw, obviously. So similarly, counsel for Jana, okay, they didn't even get her name right. I got to tell you, whoever wrote this motion's a moron. And that's not just the typos. It sounds like a whiny letter. Jana Ellis, doesn't even know. These people are idiots here. I'm not joking. We've seen it from day one. Our defendant, Jana Ellis, are married law partners working together and representing Ellis through these proceedings, right? It's Jenna, isn't it? It's J-E. I'm not wrong on that. The state has not brought these. Okay, so husband and wife law team, there's no conflict there. They're working together to represent the same person. There is no conflict. The state has not brought these relationships to the court's attention as potential conflicts because they're not conflicts. This is weird. Now Roman's motion was filed saying the private lives of attorneys in this trial was not a topic of discussion. My goodness. So this is missing the whole point of this allegation, and it's by design, or maybe this person doesn't know any better. They say attacks on the qualification of special counsel Wade are also unfounded. And I would agree, if Wade is totally unqualified, that's okay. You can have an idiot prosecutor. You can have totally unqualified prosecutors. In fact, this is great. It's great for the Trump case. We're watching the outcome of an incompetent team. They can't get even convictions for Jenna Ellis or Sidney Powell or even Harrison Floyd, returned back to custody. And that's even after copying Liz Cheney's homework. So this could be right. I actually don't disagree with this. Now, that the thoughts and views of the defense counsel on the disqualification of him because he's incompetent is, in a word, absurd. But that's not what we're talking about. Okay, we're not saying that Nathan Wade and the office should be disqualified because he's not competent. That's not what we're saying. We're saying the fact that he was appointed and paid $250 an hour when the RICO guy, the white guy who she didn't sleep with, he was paid $150 an hour and he wrote the book on RICO for Georgia. That's the point. We talk about Wade's qualifications to determine fair market value, okay, not whether it's your discretion to hire someone or not. You can hire the dumbest prosecutors in the world. It seems like you have, actually. Thanks for that. But that's your prerogative. The reason we talk about his qualifications is about compensation, which goes back to your conflict. They're missing the whole mark. And the judge is going to see this. He's going to be reading this and go, what the hell are they talking about? As a preliminary matter, no criminal defendant has a right to select a prosecutor of his or her choosing. And they cite a case for that. I swear an intern wrote this. I swear it's his criminal law 101. Same point earlier. Now, neither Georgia nor any other jurisdiction permits a criminal defendant to choose his or her prosecutor. I'm not joking you. This is hysterical. Thanks for that. They cited that. They looked this up. Thanks. And the court is aware of no Supreme Court precedent establishing a defendant's right to choose his prosecutor. Nobody alleged that at all. What are they even talking about? Now, criminal defendants are entitled to be prosecuted free of legal conflicts of interest, of which none are found around here, and so we get to pick our own prosecutors. So one need not look further than Roman's baseless efforts to undermine Wade's qualification. There's bad faith that runs through this motion. Now, while the motion makes dismissive accusations about the adequacy of his successful, decades-long legal career to lead the prosecution of defendant Roman and his co-defendants, a decidedly strange position for the criminal defendant to take. What? The truth is, Wade has long distinguished himself as an exceptionally talented litigator with significant trial experience. We're going to read through his filing. Now, he's a diligent and relentless advocate, known for his candor with the court, which, okay, great. He just talks openly with them. He's a leader more than capable of managing the complexity of this case. Citation needed. In addition to having been appointed as a municipal court judge, which handles misdemeanors and civil traffic offenses, not felonies or RICO felonies, in 3 jurisdictions, and having been asked to present topics of training on new judges for municipal courts, again, not felonies, Special Prosecutor Wade has received accolades and recognition for his skill. Now, counsel for Roman knows all of this. During a judicial campaign, defendant Roman's counsel, man, they're going to smear Ashley Merchant here, says that Ashley, the lawyer who actually wrote this, was an enthusiastic supporter of Wade's candidacy. They went and trolled her Facebook. Shout out to Ashley Merchant. We love Ashley here. She supported Nathan Wade some time ago in 2016. She said he's ethical, that he's got experience. She said he was a prosecutor, a private attorney, and a judge. And that was her post. Here's what her post looked like, right? She even wore a shirt out there. On May 24th, enjoying some Greek music, vote for Nathan Wade. Said, hey, he's practiced in every area. He's a recipient of all this stuff. And she was a vocal and even had a visual presence of him, supporting him. That's great. She supported him for whatever this position was during a judicial campaign for a judge. Okay, so she supported him, just to be clear, to be a municipal judge is what it sounds like. To be a municipal judge, not, which is a whole different category. Like, he's probably competent for that, according to her. Doesn't make him competent to prosecute felonies. But again, that's the question we're asking. It's not about whether the defense has a right to disqualify him based on his competency. They can hire an idiot prosecutor if they want to. And so this is a red herring, right? This is a distraction. It's about showing the compensation that he got for his credentials relevant to the other on the team. Saying, Fani continues, neither Fani nor Wade have any financial interest in any of these convictions, but they do, because the longer they prosecute these, the more money they can bill. They say as long as the arrangement does not run afoul of contingency fees, then it's perfectly appropriate and even routine. We do this all the time. We're allowed to bill. And we can do that here. They say Prosecutor Wade has been compensated for his time that he spent working on this case, just like all other special prosecutors have, and they make no effort to factually demonstrate otherwise. Now, references to aggregate invoices paid over a period of years may garner headlines, but they ignore the context of Wade's role. He was digging into the complex criminal racketeering scheme designed for 2020. And so comparison for his work to other prosecutors, they did less time-consuming work. Okay, he billed 700 grand, allegations are $1 million now. They billed less than 100 grand because he did the hard work. So they had more circumscribed roles. That's why he made much more money than the others, only because Wade did much more work. Footnote here saying, like other special prosecutors, Wade actually took a reduced rate. His contract's identical to everybody else and is substantially similar to the white guy, Floyd, who Fani didn't sleep with. Now, the difference is attributable to the willingness of Floyd's firm. So Floyd he took a lower rate because he's a nice guy based on its long-standing commitment to public service. Okay, so the white guy who she didn't sleep with, as far as we know, he got paid less because they're nice guys. Now, regardless, we're allowed to appoint these and we're allowed to set pay at our own compensation. If we want to pay him a lot more, we can. And we have. Some special counsels have charged $1,000 an hour. And so I can bill him whatever I want. And I think the judge might agree. So, okay, this is between you and your voters and your office. If you want to bang your special counsel and bill Georgia for that, between you guys. But if I can separate that out from the rest of the case, I think the judge is probably going to do that. Now, since Wade's appointment, he has managed a lot of people, like a whole team of lawyers. And shortly after his appointment, DA Willis petitioned the chief judge to convene the Superior Court judges to conduct a criminal investigation. And once they issued the order, then Wade jumped into work. And he worked very hard. And he got a lot of evidence from the special grand jury and all the things. Now, he was there for a lot, right? Hours and hours and hours. Now, unsurprisingly, not every witness was a willing witness. And so he had to procure their testimony. He had to get subpoenas and he had to force compliance with compulsory process and blah, blah, blah. He had to do this with out-of-state witnesses, 16 witnesses, right? So they're giving you like a laundry list of all the things that he actually did. Maybe he took notes for those. We don't know. So he did a bunch of work. That's why he got paid all this money. Our investigation led to, so this is just called kind of papering the file, right? So they just went through their file. Hey man, what did you do? Did you do any work here? What can we add to our log? It's like when you get a client complains, you know, hey, you got a flat fee or something. Hey, I want to know what you did in my case. You got to write an accounting for them, right? This is what I did on this date, filed this motion, did this, blah, blah. Kind of a pain in the butt. But that's what they're doing here. They're just saying, this is all the things that he did. This is why he's billing what he billed. Given the breadth and the complexity of this case, which is wild because they've got 0 convictions. They've got 4 defendants that have pled out, but no convictions. They're all diversion deals. And the unprecedented public attention focused on this and the highly charged political environment, the hours invoiced by Wade are wholly predictable. He deserves all that money. Now, Wade, in order to take this position, he resigned from 3 judicial appointments. Okay, so he was a judge at 3 different locations, just kept being a judge, and largely stepped away from his private practice for long stretches, which is very interesting admissions here. Isn't that interesting? So it sounds like Wade really didn't have any other sources of income, did he? So he resigned from 3 appointments and largely stepped away from his private practice. So he might have a little bit of that private practice money coming in. Did he use that private practice money to go on his Napa Valley trip, to go on his cruise ships? Or was that Fulton County money that Fani got paid him? So there's simply no honest argument that Wade unduly benefited financially from his appointments. Okay, he got $1 million billing 24 hours in a day on one day. Not even a single pee break. No financial benefit while he's going on cruises with his DA. So they say Roman's motion also wildly speculates that Fani got some benefits, that somehow she benefited from the prosecution, but they provide no support to justify that other than this little fact here. Okay, in other words, Wade had no other income. You paid him, your lover, a lot of money, and then you enjoyed the fruits of that appointment. That's the conflict. Now she says, and you always know this, now to be absolutely clear, the personal relationship between DA Fani and Nathan Wade has never involved direct or indirect financial benefit to Fani Willis. See that? Never involved any even indirect financial benefit to Fani. Give me a break, man. You guys were flying all over the place, going on these little vacays. Who was paying for that? We saw Nathan Wade was, but apparently he was using his what money? His little law firm money that he wasn't working in? Huh. So defendants have produced no evidence to suggest that there was any circumstance that would constitute a financial incentive from Fani to pursue a conviction through Wade. Yes, there is. I mean, it's wild they even say this, because if Nathan Wade dismisses the case against Trump, he has nothing to bill, does he? He has no more income coming in, right? He gave up his judgeship. He can't be a judge anymore. He resigned. He's not even working in private practice anymore. He has to spin that all back up. So he took this appointment, wrapped up all of his other stuff, pocketed $1 million, and then used that money to take Fani on cruises. If that stops, if there is a dismissal of the case, all that spigot of money goes away. Now, there are no joint and shared finances or financial accounts. Who cares? No one cares. There is not now or has never been any shared household, okay? We still see the conflict as following through his account back as a benefit to Fani. There is no financial dependency or merging of daily expenses. Well, you're not married. Okay, thanks. Financial responsibility for personal travel taken, here we go, is divided roughly evenly between the two, with neither being primarily responsible for expenses of the other, and all expenses paid for with individual personal funds. What funds? What personal funds? He resigned all of his judgeships. That's his money, and he's getting a lot of it. That's why he divorced his wife immediately after getting the contract. So both are professionals. They both have substantial income. Neither is financially reliant on the other. No, you're not. Well, he is reliant on Fani. I got to tell you that. That's not accurate. That's not accurate at all, right? And that's like dishonest. So he is absolutely reliant on her. If she does not renew his contract, what's he going to do? He's got to go back, run for office again, get reappointed to those judgeships that he resigned from. He's got to spin up private practice. You know, it's a lot of work to build a private practice. I did that. And you don't just get to take a couple of years off and then come on back in. You know, he's been taking years off prosecuting Trump. So he's just going to go back. He's like literally reliant on her, and they're lovers. So that's not accurate. That's dishonest, like by the records. So the facts here, she says, are readily distinguishable from contingency arrangements or other scenarios where a true financial conflict may play a role. Yeah, I agree. It is distinguishable from that. But that's not the only standard. All right. So given this total absence of financial conflicts, they say defendant Chile's, are they saying Romans or the Chile? Okay, it's from the Chile motion. They say multiple ongoing conflicts is not persuasive. Looking to an order disqualifying the DA cannot support his motion. We need more than a theoretical or speculative conflict, like an actual conflict, as we just articulated. Persuasively, the prosecuting attorney's counsel, that's tasked with assessing potential conflicts and providing governance on this, found no conflict of interest in the political activity that they they cited for that disqualification. All right, now continuing, they also talk about Fani and her church conversation. They say her public comments are all within legal and ethical rules and guidelines. They say Trump's motion that raises concerns about the public comments made by Fani that neither reference this case nor the defendants is totally meritless. She was talking about something else, not this case. She didn't use Trump's name or anyone else's name. So they say the motion makes no serious legal argument. It establishes no violation of any ethical rules. It makes no real effort to link the public statements to any legal standards, and instead raises vague and plaintive cries of due process. Hopefully they explain all that, because that was a big mouthful. Now here, Trump has presented no direct evidence that the attorney was motivated to treat him differently because of his race, gender, or any other improper ground. Again, that's not what anybody's claiming. Like, nobody's saying that she was attacking Trump and being racist towards Trump. What is this person even talking about? Motivated to treat Trump differently because of race. Like, this is not an equal employment discrimination conversation. It's that she was talking to the jurors in Fulton County and calling the defendants racist. Okay, voir dire, not motions for disqualification, is how you should deal with this. So the fact that I went out and ran my mouth at my church and everyone just sat there and was like, yeah, go girl, for whatever reason, was here saying the impact of public statements on a prospective juror is evaluated. Should we just deal with it during jury selection? Did you hear what she said? Oh, you did? Did that make you unfair? Can you be fair and impartial? Yeah, I can. Okay, great, you're on. Trump's motion fails to establish an adequate basis in law, and he can't even articulate any standards. And so our appointment of Nathan Wade complies with the law, saying there's no structural error. We've already explained this. They are misstating the requirements for special prosecutors. Remember, there were some procedural problems. They said that he should have signed an oath and they should have submitted some paperwork. But they say that requirement does not apply to Special Prosecutor Wade because it shall not apply to any deputy who may be employed in particular cases only. So given that, this case was Wade's primary focus. Again, right, the guy has no other work, so he's literally beholden to Fani Willis. She doesn't renew it, he's done. Fires him, you're done. Get out of here. Clearly relying on him. Now, as this court has noted, regardless of any of the particularities, regardless of his omission to take and file the oath, there is a de facto officer theory. Okay, so it's a de facto theory, the fact that he's kind of acting in it, a lot of case law, just saying, we don't need to even go through all those mechanisms. It's just, we just did it despite the lack of filing, they say. Okay, even though he didn't file it, all Special Prosecutors Acts while in office would even be valid even as a de facto officer. So even though he didn't like go through the mechanics, it was still valid under the color of law. And most critically, they say the defense has failed to establish how any of his actions would result in harm or prejudice to them, how any of this would have changed the course of the prosecution. They haven't established any constitutional violations either, and they have to show harm before you can take action on this, Your Honor. And they also misunderstand the contracting procedures. Contracting with professionals is a well-established practice afforded to many prosecutors. A DA can use the funds however she wants by the county and commissioners, literally however she wants. A DA can use the funds allocated to the office by the county commissioners as he or she sees fit. That's the rule in Georgia. She said here, she's citing this law. Wait a minute. She cited the Atlanta Journal-Constitution. Someone else is saying they can do whatever they want. So the appointment of Special Wade, a former prosecutor, judge, defense counsel, and managing law partner is wholly appropriate. It's my money. I can do whatever I want with it. And no one articulates how the appointment of Wade or the appointment or using that money essentially is a problem. They say Willis is a state officer. She's elected. The people put her in there. So she is simply not obligated to conform with the requirements that are applicable to other county officers. See that? So it looks like Fani has a little bit of immunity going on here or something. Now, claims for disqualification are completely without merit, they say, saying none of those provisions apply. And a lot of this stuff is more technical stuff. Any allegation that ORCA or other earmarked funds were misappropriated are false. As a general matter, the DA has the authority to execute contracts. Payments pursuant to a contract can be paid in different ways. There's a payment voucher. They give us the explanation here. Paying a contract via a PO requires two things. Now, a memo is created. They walk us through all this procedural stuff that, again, the judge is going to be like, what are you talking about? While it would have been entirely permissible for all payments to Wade's office to have been paid via purchase order, we followed the rules and we went through a more robust process and we sought our CFO's approval on all payments to Nathan Wade. And so each invoice was independently reviewed for compliance with Wade's contract and a budget line was utilized appropriately. So we could see if anybody, so in other words, wild, nobody caught the fact that he billed 24 hours in a day. They just paid him out for it, it sounds like. So they say, we went through a rigorous process before we paid him, so therefore it is not an illegal scheme. We're not trying to hide anything. And again, nobody's saying that you were trying to hide anything. Well, we think that you were trying to hide something, but not that he was reporting his money laundering and invoices. Like, nobody's saying that. In conclusion, they say, we know that we're scheduled for a hearing on this. And they say that this defense team, Trump and Mike Roman and others, and lawyers for them, they've provided notice of subpoenas. They're trying to subpoena a bunch of people from Fani's office. Yes, we love to hear that. 8 of them at last count, including Fani Willis herself. They're also subpoenaing Wade, Wade's current and former law partners, and many others have been subpoenaed as well. Now, Roman's lawyer has also attempted to subpoena Wade's personal bank records because we want to see. Yeah, we want to see if he's got other sources of income, right? Wouldn't that be interesting? Because he says that he used his cruise money and his flight money from his personal record, his personal funds. Okay, well, where did those funds come from? From Fani, right? Thanks. Records, and has gone so far as to subpoena an attorney who at one time represented him in his divorce proceedings. The hunters become the hunted. This is when defense attorneys just go like rabid, and I absolutely love it. Doesn't happen too often. Like piranhas, man. Just, subpoenaing everybody. Let's go. Both are incredibly inappropriate efforts to intrude into our personal life with little to no evidentiary value. That's not true at all. You guys have a conflict, not them. The state, in an effort to be as candid, as transparent with the court as possible, has given our affidavit of Prosecutor Wade, and we've included other exhibits directly establishing facts that counter the wild and reckless speculation that the motions have advanced. That effort should not be viewed as an acquiescence that this extraordinary level of invasion of privacy, well, that's what you get in the public eye, is in any way justified or that it will be repeated. The legal basis for each of these motions to disqualify falls woefully short of what would meet the standards, and they say no further factual development is necessary to deny these motions now. In other words, we do not want a hearing, Judge. By issuing these subpoenas to these individuals with little or no knowledge of this fact, they are seemingly anticipating a hearing that's going to last for days. Let's go. Perfect, man. I'll clear the calendar. We'll clear the calendar. We'll be here. Garner more breathless media coverage and intrude even further into the personal lives of the prosecution team in an effort to embarrass them and harass them personally. Or you guys could just recuse, like just pull yourself off the case and just turn it over to someone else. Now, this is not an example of zealous advocacy, nor is it a good faith effort to develop a record on a disputed legal issue. It's a ticket to the circus. No, there is a conflict. You have a direct motive to continue your prosecution, even when there is not a valid basis for it, which in my opinion is the whole case, the whole RICO case. All that $1 million that Nathan Wade got, he should have gotten zero. This whole thing is a charade. It never should have been brought in the first place. Defendants have done nothing to establish an actual conflict of interest, nor have they shown that in handling the case. They've acted out of any personal or financial motivation other than getting $1 million and, like 2 years of free vacations. The record before the court falls short of requiring disqualification, but alone because there is no evidence of acting out of personal interest and without any basis for the extraordinary relief of disqualifying the DA or Wade, the motion should be denied. Saying that their failure to support their demands for extreme relief with evidence, the state respectfully asks, consider the Wade affidavit and then deny this without further spectacle. Terrible motion written by Anna Green Cross. So she submitted that, probably written by, some other people on her team. She's just signing off on that thing. And they got to just be, talk about being deflated and defeated. Like if you're Anna Green Cross, if you're John Floyd, if you're these guys and you're going, this is what our history is going to be. You're excited when this case starts, you're like, we're going to prosecute Trump. Yeah, this is going to be a historic case. We're all going to get book deals and everything. And now they're defending Wade's hot dog. Wild. They must feel just like total losers because their involvement in this thing. So here's Exhibit A. This is Nathan Wade's affidavit. He says, my name is Nathan Wade. I'm over 18 years of age, no legal disabilities. I live in Georgia. I made this affidavit with sound mind. I am a member in good standing of Georgia, got a lot of experience, all these other things. Northern District of Georgia, Middle District of Georgia, great. He's admitted to all those things, basically filled the paperwork, get admitted, boom. I've served as prosecutor several times during my career, first as the assistant solicitor in Cobb County, then as special assistant attorney general for the state of Georgia, and then as special prosecutor for the Atlanta Judicial Circuit. So don't know what he did there. I opened my law practice in 2000. My law firm has employed between 4 and 9 employees. I have served as a civil attorney in private practice representing individuals, businesses, and corporations. I have served as a criminal defense attorney. Hundreds of individuals charged with felony and misdemeanor offenses. I've tried many felony cases, including clients in serious matters, but not limited to capital offense murder, rape, armed robbery, as well as aggravated assault. That's a big case. Now, some of these cases did garner national media attention, so that's great as a defense attorney. Now, I was retained as outside counsel to represent the sheriff of Cobb County. I was contracted to conduct an external independent and accountability assessment. Right, and I think that's where he concluded that he had no notes, right? $5.50 an hour, he had no notes. They brought him in because Fani's DAs, people are dropping dead in the jails all over the place. And of course, he went to go investigate it. They said, what kind of work did you do? He said, I didn't take any notes. Yes, it's all in here. I began serving as a municipal judge all over the place. I was proud to be the first African-American municipal court judge in Marietta and served on other state courts. I've also presided over criminal trials. I received the President's Award from Municipal Court, and over the course of my career, dozens of accolades. And again, it's about the compensation relative to the others. Now, I'm 25 years as an attorney, high-profile athletes, complex things. I am not now, nor have ever been an employee of Fulton County. On February 15th, I completed training that allowed me to be a municipal judge. It's a whole resume booster here. All that's irrelevant. We're now at 17. Now, while presenting at a training course, I met Fani Willis back in 2019. Then the newly appointed chief judge of the city of South Fulton. Met Fani in court at a training. Now, after being elected as the first female DA in Fulton, Willis asked me to serve on her transition team. In the spring of 2021, Willis asked me and two other attorneys to assist her in looking for a competent, trustworthy attorney to manage and lead the investigation. DA Willis was able to offer no more than $250 per hour, capped at a monthly rate. That hourly rate was significantly less than the market rate in the area, but my previous rate when working for the government was $550, but the DA was offering less than half of that. Lawyers we spoke with about taking on the work were hesitant because of their safety issues for their families, and the DA and other lawyers approached me. Understanding the demands, I told them I was not interested in giving up my 3 judicial appointments or taking time away from my role as the managing partner and the primary business generator for my firm, which further confirms that he got his money. He's getting all of his money from Fani, or a huge portion of it. Now, then in 2021, I agreed to serve as special prosecutor. I had officially resigned from my other positions. I contracted with them. This case is extremely complex. My role included a lot of work. As special prosecutor, the case required the vast majority of my time. He's totally beholden to Fani, as is reflected by my invoices. In many instances, I documented work that would have exceeded my contractual cap and did not request or receive payment for the work that I did. I actually did more work than I got paid for. Now, my private practice has continued to generate revenue separate and apart from my compensation, so that's that personal money, and that's why they want his bank accounts to see what money paid for their trips. Now, while professional associates and friends since 2019, there was no personal relationship between Willis and me prior to or at the time of my appointment, which is very curious because he filed for divorce the next day after he signed the contract. Says Willis and I then in 2022, here's where they admit it, DA Willis and I developed a personal relationship. In addition to our professional association and friendship. Now, I have no financial interest in the outcome of this case or in the conviction of any defendant, which it's like he doesn't get a contingent fee, right? If Trump gets convicted, he doesn't make $1 million. But if the Trump case goes to trial and he's a special prosecutor, he is going to make a lot more money than if he says, you know, I've investigated this and there's no evidence here. This is ridiculous. And he makes a fair and impartial decision to dismiss it. That would go against his financial incentive massively. And Fani is getting a direct benefit from that, right? Because she's paying him that money. So no funds paid to me in my compensation for my role as special prosecutor have been shared with or provided to Fani Willis, which I think that's probably true. I think that she, he didn't write her a check or anything. Like, here's your cut, baby. Thanks for the contract. And here, the DA received no funds or personal financial gain, right? That's a term of art. We don't know what exactly that means. If he paid Fulton County money for those cruise ships, that's a gain. But yeah, I would say, she probably didn't get, bigger stock portfolio or something, but all right. I never cohabitated with DA Willis, would be fine if you did, I guess. The problem is that you have a conflict, not the specifics of the relationship. I never shared household expenses with Fani. Again, it's like, okay. Now, I never shared a joint financial account of any kind with Willis, and we are both financially independent professionals. Expenses for personal travel, here it comes, were roughly divided equally between us. At times, I have made and purchased travel for Willis and myself from personal funds. At other times, Willis made and purchased travel for she and I using her personal funds. Examples of Willis purchasing a plane ticket for she and I with her personal funds and for our personal travel are attached. So there's nothing funny going on here. It's just two little lovebirds who are all above board, signed here by Nathan Wade. And so they've got a bunch of exhibits down here, and some of these are just monstrous images. Like you can see, he's got articles. This guy, this is an article from some time ago. He says, I worked on all these cases, Georgia's top lawyers, which a lot of these, let's see here. A lot of these you can just pay for, by the way. I don't know about these like NAACP awards, but like some of these like top lawyers, they say, you're great. Kind of hand these things out like Skittles. All right. So all of his awards. I really am qualified, I'm competent. I'm qualified. So then, here are his records. And we've seen a lot of these. A lot of money, 35 grand. It's good money, man. 1 month, 35 grand as a lawyer. That's pretty good, good, man. I gotta tell you. It's a lot of hours that he's just billing. Boom, boom, 37 grand that month. We're doing team prep and motions today, 8 hours. I didn't even take a pee break, 8 hours, 2 grand. It's crazy. Oh, all right. So these are his exhibits. Here are your flight receipts. Okay, so here's Fani. And apparently, yeah, Fani Willis. What kind of flight did she buy? Oh, they didn't even sit together? Or are these on flights, 2 separate flights? Yeah, all right. So Fani bought some tickets as well. And it's the true love defense, man. It's the true love defense. They loved each other. They used separate funds. There's no conflicts here at all. The fact that she funneled him $1 million and some of their angry threats, that are coming their way. And so, my friends, that is Fani Willis's response. And of course, she is totally above board. She recognizes that this is not who she wanted to be. In fact, this clip came up from some time ago where she explains that people should hire her, elect her, because she would never do the things that she's been accused of doing. She would never turn her office into anything about money or sex. In fact, she would never sleep with her employees. The old guy did that, and she wouldn't do that, even though she just, admitted to doing that, like literally in her own filing from Fulton County. Here's Fani.
The district attorney's office in Fulton should be the beacon of the Southeast. It should be the absolute best office between Washington, D.C. and Miami. And right now, what you have is a office of dysfunction and corruption, and we deserve better. And I am the right choice to improve it.
Corruption, Ms. Willis, that's a strong word to level against the office that Paul Howard has run for nearly a quarter century. If he gets reelected, it'll be more than 25 years.
You have a DA sitting there that doesn't have the qualifications and the experience to do the job. What I can guarantee you is with my reputation, with my community ties, I am going to be able to attract the best and the brightest minds to that office. You're sitting with someone today that actually wants to make a difference because they deserve a DA that won't have sex with his employees. Because they deserve a DA that won't put money in their own pocket when it should go to benefit children, because we deserve better.
Okay, not going to sleep with their employees. She just admitted in her own filing that she was sleeping with her special prosecutor, Nathan Wade, enjoying a nice Nathan hot dog. We've got here, Donald Trump responded to this thing, says, Fani Willis, the DA of Fulton County, just admitted to having a sexual relationship with the prosecutor that she, in consultation with the White House and the DOJ, appointed to get President Donald J. Trump. By going after the most high-level person and the Republican nominee, she was able to get her, quote, lover much more money than she would be able to get from the prosecution of any other person or individual. That means that this scam is totally discredited and over. And I wanted to pause on this very briefly and just explain why I think we kind of want to keep Fani around. My predictions are that the judge is not going to disqualify her and not going to dismiss this case. Maybe he'll deal with this later, but I think he's going to have a tendency to want to keep things as the status quo, and I don't think that's necessarily a bad thing. Let's game this out just a little bit. Setting aside the dismissal issue. Okay, let's back up. If the judge dismisses the case, game over. That's the Super Bowl victory. It's over. We won. Don't need to think about it again. I don't think he's going to do that. He's going to say that their personal relationship doesn't taint the whole case and he can separate the two. He'll deal with some of that in voir dire. He'll deal with that in filings from the defense, make rulings on evidentiary issues and so on and so forth, but won't dismiss it. So let's set that aside. The next thing, what about disqualification? Will he say Fani's got to go and we get a new prosecutor? So let's just play that one through. The case doesn't get dismissed. What about disqualification? Well, we could get a disqualification and the case could go to a new prosecutor. The new prosecutor could take a look at the case and dismiss it. Okay, that would be a victory. That's one possibility. Is that likely? I don't know. Probably not, because a prosecutor doesn't like to dismiss cases. They generally will keep them going. So probably unlikely, but it is a possibility. Another possibility is that a new prosecutor gets the case, Fani gets thrown off, and they're great. Like they're actually competent, right? They're actually intelligent. They actually know what they're doing, and they don't have all the partisan hack baggage that Fani Willis does. They're not banging their special counsel. You know what I'm saying? So we actually get a better, more competent prosecutor who's going to do a better job at creating this narrative and driving it through, driving it home. So that's actually a bad thing. Now, on the opposite end, what if the judge does not disqualify Fani? So now we take that to the next logical step. What happens if Fani in a rigged jurisdiction gets a conviction? Okay, that's going to be the most illegitimate conviction anyone's ever seen, right? Everyone's going to go, oh gosh, Fani, Fulton County, the same woman who was sleeping with the special prosecutor who grifted $1 million off, the whole saga is going to be there. It's going to be a monstrous shiny object. We're going to see this big shiny object that's going to distract from the whole case. So even if she wins, right, we get this RICO charge, it's Fulton County, let's say it's blue, blue, they vote against these defendants at a trial, no one's going to care. Everyone's going to go, oh gosh. And she's going to be this big shiny object that just hangs like an albatross around the neck of the Trump prosecutors. She's going to be so big, it's going to subsume, the big Fani is going to subsume all of the Trump prosecutions. That's what it looks like. Okay, they're paying him $1 million to go after Trump, and she's his lover. How is that legitimate at all? So if she stays on and if she is successful, it delegitimizes the whole thing. That's a good thing. Defense attorneys oftentimes try to create their own shiny object to draw attention to that thing. You want it away from the defendant and towards the bigger thing, towards something that's distracting. This is here. They've already got it. It's right here for us. And so the fourth option, of course, is she stays on the case and loses, which is also a victory as well. So the way I see it, she's kind of a gift. And if this whole thing, her performance is very bad. So if she doubles down on this and she says, I'm not recusing, I'm staying on this case, the judge keeps her on the case, maybe she will try to run this case in August or in October. And that could really crystallize all of the critiques that we've had about these weaponized witch hunts. She's going to be the symbol for it. And I can't think of a better person, honestly. So if we're going to have a prosecutor on this case, I want Fani. She should stick around. And I think that the judge is probably going to try to craft this thing through and try to deviate away from the salaciousness, which is all true, and say the voters can deal with that, right? You guys can deal with that on your own accord. I could be wrong. We'll see where it goes. We are going to be here for the hearing on February 15th. And so make sure you're subscribed, my friends, wherever it is you're watching this. Don't forget to hit that like button. If you see it handy, we'd really appreciate that. We've also got all of the PDFs are going to be on our website, robertgovea.com. Links are down in the description below. And so we'd love to see you there. Sign up for our daily newsletter, grab a hat from the shop so you can watch the show and look good while you're doing it. And we'll look forward to seeing you back here on the next one.